Welcome to the 22nd lecture of this lecture series on international arbitration practice. In the last few lectures, we have been dealing with how to draft a notice of arbitration or a notice invoking arbitration. In the last lecture, we started off with a simple commercial dispute emanating out of a design automation contract. We had drafted the formal portions of the notice of arbitration. In this lecture, we draft the substance of the notice of arbitration. Before you start off with the lecture, you would want to have a look at the fact sheet whose link is provided in the description to this video. We recommend that you pause this video right away, download the fact sheet and read the same at least twice or thrice so you understand the factual situation and the context in which this notice of arbitration has been prepared. If need be, and I suggest this is the right method, you can have a look at the previous lecture and then come to this lecture. Well, coming back, the notice of arbitration in the last lecture would look something like what is on your screen. The substance part of the notice contains about 7 parts. These 7 parts can be found in any notice of arbitration relating to a money claim. The first part of the notice of arbitration deals with how the contract was formed and the relevant clauses in the contract. The first part says, pursuant to tendering process, you, that is the contractor, were awarded the contract referenced at serial number 1 above. Serial number 1 is the agreement. And it says, as per the provisions of the contract, you were obligated to complete the scope of work under the contract by 31/3/2023 and hand over all the deliverables as specified by deploying competent manpower. You were to complete the contractual milestones within the time provided in the contract. The second part, as you would notice, deals with the manner in which the contract was actually performed, the milestones that were completed and the payments that were made. It says, as on 30/4/22, you had completed 2 out of the 7 milestones and payment of rupees 2.5 crores or 25 million was made to you on 5/5/22. After 30/4/22, you have not deployed any personnel to perform the contract. As you would appreciate, the contract had to be completed by February 2023 as the project was being monitored by our top management and had implications on the performance incentives to the employees of our branch, which had been informed to you during numerous meetings prior to and at the time of signing of the contract. The third part of the notice talks about the contractual breaches. So the first part spoke about the contract, its formation and its relevant clauses. The second part dealt with the manner of performance of the contract, the milestones completed and the payments made, and the third part deals with the contractual breaches. Here it says, after the completion of 2 milestones, you failed to deploy human resources for getting the remaining work completed. Despite several reminders, you have failed to complete the work under contract. Consequent to your utter disregard for the contractual commitments, we had no other alternative but to invoke the termination clause in the contract. Accordingly, a notice of termination dated 10/5/22 was sent to your office, which was not responded to. The fourth part concerns the actions taken by the client for addressing the breaches, such as going for risk and cost contracting and termination. So it says, consequently, we had no other option but to terminate the contract through our letter dated 25/5/2022 and get the unfinished work completed at your risk and cost. Note that the notice of termination was sent on 10/5 and after 2 weeks, that is after giving reasonable notice, the contract was terminated on 25/5/22. Then this part goes on to say, we had also encashed the bank guarantee of rupees 10 crores owing to your contractual breaches. Oh, sorry. As per the fact sheet, the bank guarantee was of rupees 1 crore, and accordingly we've changed it here. Okay. Then this part goes on to say, we had accordingly informed you of the award of the risk and cost contract via our letter dated 1/6/2022. The fifth part of the notice deals with losses and their calculation. Here, the total liability out of the contractual breach is rupees 2 crores or 20 million. The notice says in this regard, we had incurred a total of rupees 10 crores, that is 100 million, for getting the work, that is the unfinished work, completed at your risk and cost. In addition, we had also incurred an amount of rupees 50 lakhs, that is 5 million, towards superintendence and administrative charges, which works roughly about 5% of the total contractual value. As such, we have incurred losses to the extent of rupees 3 crores or 30 million in getting the contract performed by a third party. Contract performed by a third party owing to your various contractual breaches. This 3 crores work out like this. See, the work that was performed was 2 milestones, for which a payment to the tune of rupees 2.5 crores was made. The remaining work was worth rupees 7.5 crores. Because of the failure of the contractor, the work had to be performed for rupees 10 crores. That is, the 7.5 crores became 10 crores. So therefore, the difference is rupees 2.5 crores. In addition to that, superintendence and establishment charges of 5% were incurred, that is 50 lakhs. So 2.5 crores plus 50 lakhs comes to 3 crores. So that is how this losses have been calculated. Now coming back to the notice, it says, after deduction of the security deposit in terms of bank guarantee appropriated towards the dues, the total dues owed by you work out to rupees 2 crores as per the below details. So serial number 1 is the contract price for executing the unfinished work at the risk and cost of the contractor, which is 10 crores. Then serial number 2 is the superintendence and establishment charges, which works out to 50 lakhs. Then the 3 is cost of executing the balance work under the original contract, which was, as we said earlier, 7.5 crores. And the security deposit appropriated towards the dues is 1 crores, which was in the form of bank guarantee. So what we do is we add 10 crores plus 50 lakhs, which comes to about 10.5 crores. Then we add 7.5 crores with 1 crore, that is 8.5 crores. So the difference is 2 crores. In addition to that, this part also provides for interest. It says the said losses include expenditure relating to the performance by us of the scope of work under the contract and other costs, including but not limited to supervision costs, damage, etc., direct or otherwise. In addition, you are also obligated to pay interest at the rate of 24% per annum on the above amount. The sixth part of the notice of arbitration deals with liability for payment. So in this particular facts and circumstances, the notice says you are liable to pay this amount jointly and severally. Here you must recollect from the previous lecture that there were two parties who constituted the contractor. One was the Singaporean parent company and the other was the Indian subsidiary of the Singaporean parent. So we at least as per our fact sheet, we were to include both these parties in the notice of arbitration, although the agreement was signed by the Indian subsidiary. So this part says you are liable to pay this amount jointly and severally. Accordingly, a demand letter dated 5/3/2023. The demand letter should read dated 5/4/2023, referenced above, was given to you to settle the above amounts with interest within 15 days from the receipt of the same. However, no action in this regard has been taken from your side despite various reminders. Then the last part of the notice concerns invocation of arbitration and the appointment of arbitrator. Here it says, since you have neither replied to the said demand letter nor have you settled the above amounts, we have no other recourse but to invoke arbitration. Therefore, we hereby invoke arbitration in accordance with the terms and conditions of the contract and appoint Mr. Jalan Goswami, former General Counsel, Mandai Technologies Limited, a Fortune 500 company, to be the sole arbitrator to resolve the above dispute. His declarations of independence and impartiality and of availability for acting as arbitrator are annexed here too. And then there is a signature. We have also provided the link to this sample notice of arbitration, which you can download and keep and use it for yourself. That's all in this lecture. Bye bye and stay safe.